Distinguished colleagues, dear students, I'm really glad to be here and to meet all of you, the most dedicated mediation proponent in Europe and in the world. I would like to thank the organizers for inviting me to this wonderful event and for fantastic organization, of course. But I would like really to start with something maybe strange, maybe not. Happy International Restorative Justice Week. As most of you probably know, this week, our colleagues, friends, partners, so-called restorativists, are celebrating the International Week of Restorative Justice, and of course, a victim-offender mediation as one of the most widely spread restorative justice models, universal model, also not a mandatory, I should clarify. But now we will speak about mediation sui generis as a really great invention and innovation and phenomenon, and a lot of words could be said here. I'm invited to speak about the Bulgarian model of transitioning to mandatory mediation. And right now, I should say it's a very difficult task. First of all, after Elena, it is almost impossible. But second, Bulgaria, I should be sincere with you, is not the world vanguard model of mediation. We are still beginners, let's say, but I do believe that I have something to share with you. So, please allow me to start with some background information. I have prepared plenty of slides. Stay assured that I will skip some of them. A lot of text, because at that stage we have mainly text, and I will explain this. So, the background information. There was a rocky way of mediation in Bulgaria from the very beginning, year 2004, till now. From an entirely voluntary option to a co-opted from the court opportunity in numerous clauses cases. Although based on the relevant European Union acts, the case law of the European Court of Justice, the case law of the European Court of Human Rights, I should say that the Bulgarian model of transitioning to mandatory mediation could be defined as somewhat cautious and gradual. Simply because Bulgarian mentality didn't readily accept mediation as an alternative dispute resolution method, hence the relatively limited number of mediations. There was and there still exists strong resistance from judicial society to mediation, hence the lack of referrals. However, it was clear that we need a change. Needless to mention the costs, the expenses, missing satisfaction, etc. So, strange, but at least once, the state institutions, the NGOs and academia were at once. We have to move to a new culture of conflict resolution, even imposed more or less by force. That's me, mandatory mediation. Of course, we had our local debate about pro and contra this type of mediation. Can happiness be forced? This was the core question. And we should recognize that mandatory mediation is a challenge in the doctrinal aspect, because it is important to what extent and how it is compatible with the fundamental principles of mediation and access to justice, especially voluntariness. But we have drawn the arguments from Alasini case and some other case, and finally we have our legal framework of mediation, including mandatory one. The first act was Mediation Act from year 2004, last amended February this year, when the mandatory mediation was introduced, as mentioned, thanks, dear colleague, it will be in effect since July next year. We had important Soft Law Act Regulation number 2 about the training of mediators, ethical, procedural rules, etc., which is now under revision. But what is the latest and greatest? These are the brand new acts that we have since October, 30 October this year, and I even do not know exactly their names, so I have to read them. They are on the selection, status, and activities of mediators in court mediation centers, and Regulation 11 on the structure and organization of the activities of court mediation centers where the mandatory mediation will take place. How we introduced, at least legally, mandatory mediation in Bulgaria? Through the new regulation on mediation in pending court cases. And here the first enigmatic variations appear and the need for a narrow interpretation, because it is explicitly written in the law that in the cases provided by the law, the court shall oblige the parties to participate in the first meeting of mediation procedure. And that is our mandatory mediation, the first meeting of procedure. Of course, there are some other fundamental standings in the Mediation Act, plus regulation in some other acts. Most important is the new Chapter 6 of Mediation Act. And now I'm going deep into the issue. According to Article 19, I'm feeling like I'm in my faculty with law students, but still, Article 19, in the cases and under the conditions stipulated by law, the court shall oblige the parties to a pending court case to participate in the first meeting in a mediation procedure will take place in a court mediation center of the relevant court. This mediation procedure is carried out by one or more mediators from the list of the court. They are designated by the center, court center, or they could be specified by the parties themselves. And the parties should participate in good faith in a first meeting in a mediation procedure, as already mentioned, or for 1 to 3 hours. And that's all. Yes, of course, could be prolonged, but this is always possible with mediation. If there is an agreement, it should be in writing, it should be approved by the court. If no, the court could continue to examine the case. So, but a little more theory. Our legislator adopted a dualistic approach to regulation of mandatory mediation. On the one hand, it foresees hypotheses in which mediation is unconditionally mandatory. And on the other hand, it settled cases where the court referral to mediation is a matter of discretion, something similar. Detailed regulation in the Civil Procedure Code, because we refer to mandatory mediation, mainly civil and commercial disputes. So, there are 6 hypotheses enlisted in the Civil Procedure Code when the court shall oblige to parties to participate in a mandatory mediation, and they are explicitly written in the law. I will not read all of them. There are some cases under the Ownership Act, as you see, partition proceedings, some other cases under Condominium Ownership Management Act, some commercial cases under the Commerce Act. It's too long to explain all in details. I should say a few words about the discretionary mandatory mediation, when the court may oblige the parties to participate in this procedure. And these are 12 hypotheses when the court can decide should it refer the parties to the mediation or not. Most of them are from family nature, let's say divorce, parental rights, maintenance, relationships with the child, and some others, relations with grandparents, plus some monetary or non-monetary claims with a small claim cost of up to 25,000 Bulgarian leva, plus some other cases arising from employment relationships, from membership rights in a commercial company, and intellectual property rights. As it is discretionary mediation, of course, we need referral criteria because the court should assess and estimate whether the case is appropriate for this mediation. They are also enlisted in the law. As you see, some of them, permanent relations between the parties, multiple claims, the cost of proceedings, when the cost of proceedings may significantly exceed the material interest. In the case, of course, mediation is the better option, plus some other circumstances explicitly written in the law. But what is also important, that we have also some excluding circumstances. And the court shall not oblige the parties to participate in this procedure if it is precluded for some cases. For example, some extreme domestic violence cases, if a state or a state institution is a party in the conflict, and some other things. When it could be referred, of course, at any stage of the case after the expiry of the period for submitting an answer to the claim and until the end of the court proceedings. The parties are obliged to participate only once in the proceedings, and the duration is up to 2 months. Of course, could be prolonged up to 6 months. About the agreement, no great interest here. Could be approved, could not be approved. The situation, it is more important to say that there are more options for mediation in Bulgaria, for mandatory mediation in Bulgaria, even at the appealing instance when the first instance is missed for any reasons. Mediation is in fast-track proceedings in the Civil Procedure Court and partition procedures. Our legislator also envisaged some expenses or incentives to stimulate the parties to participate in mediation. These financial loss are very important. As you see, instead of 50%, 75% of the paid state fee could be refunded. The cost of the first mediation session within the statutory limits is paid by the court budget. It is also important. A brief analysis, because I have no time for longer analysis. I would like to say that this was maybe the only possible way to introduce mediation in Bulgaria, according to our specific situation, because this dualistic approach ensures a smoother transition to mandatory mediation, and this gradualism corresponds to the need for careful assessment, as well for raising of public awareness for mediation. Now it's too early to make an accurate assessment. There is no accumulated practice, as mentioned, but we have discovered some underwater reefs embedded in the legislation. Only 2 examples. There is already a confrontation between the mediators in the court centers and the other mediators. In the court centers should be also a mediator with law education, and some other people, other mediators find this discriminatory. In the court centers also, one more problem. They will receive referrals, funding, administration, and the autonomous centers lack all of this. So we already started to think how to address these problematic issues. In conclusion, there was development in Bulgaria, finally, I would say, I believe, in the right direction. The situation still is pretty dynamic. Mediation is expanding, it's not a mainstream, and it is never a mainstream. The mediation infrastructure, especially mandatory mediation infrastructure, is a contested terrain still, and we are expecting the time when the first mediation session will be a must. We also hope that the mediation will become an imminent part of Bulgarian mentality, and we do believe that we are on the right track and moving in the right direction. Thank you very much for your attention.